Good evening, gentlemen. I'm sure we all had quite an awesome day. Alright, so welcome to tonight's online session. I'm still your host, O.O. Stevens. And tonight we are going to be looking at the topic Sources of Civil Procedure. Sources of Civil Procedure in Civil Litigation. Sources of Civil Procedure in the course Civil Litigation. Now, the following are the sources of civil litigation, or the sources that can actually be referred to in matters that are civil based, not criminal matters, matters that are civil based. One is the rules of court. The rules of court, such as Supreme Court rules, Court of Appeal rules, Federal High Court rules, High Court rules, Abuja High Court rules. Note that rules of court are the primary focus of the study in civil litigation. Note that the teaching on the course civil litigation, 90% of the time, what we normally make use of are the rules of court. And you also know that for the purpose of law school curriculum, what the two rules that they used to teach are the High Court of Lagos rules of 2019 and High Court of FCT rules of 2018. So it is worthy of note that you should be aware that the rules of court are the primary focus of the civil litigation, or the primary sources vis-a-vis law school teaching and the curriculum. All right, the next source of civil litigation are statutes. Statutes creating the court. For instance, there is what we know as Supreme Court Act, there is Federal High Court Act, there is Court of Appeal Act. So those statutes can also be made reference to in the course of handling any civil-based matter. But you also need to know that where there is a conflict between the rules of court and the statute, then the conflict will be resolved in favor of the statute, because there could be instances whereby a particular section in the rules of court would be conflicting with a particular section in the statute creating the court. Please, statute creating a court is different from the rules of court. The rules of court are more procedural, while statutes are more substantive. So the statutes are like the court would not be in existence until there is a particular law that establishes that particular court to be in existence. But rules of court come into existence after a court has been established. So these are specifically the rules that the court ought to observe in the course of the trial in that particular court. So what we are talking about now is that the rules of court are most often than not, in some instances, conflicting with the statute creating that particular court. And the question now is, what would be the attitude of the court where there is a particular section of the act that is creating that court that is actually conflicting with a section of the rules of that particular court? And we said that such a dispute or such a conflict is going to be resolved in favor of that act or in favor of that statute that has created that court. Or we have other statutes such as Sheriff and Civil Processes Act. We have Judgment Enforcement Rules. We have Companies Winding Up Rules. We have Matrimonial Causes Act. So these other statutes can actually still be applied, because when you get to the issue of service of notice, the issue of issuance of notice, service of writ, you will notice that there is most often than not the presence of the Sheriff and Civil Processes Act. When you get to the issue of enforcing the judgment of the court, you will see that there is a need for the judgment enforcement rules. When we get to the issue of winding up of companies, you will see that there will be a requirement for the company winding up rules. When we also get to matters relating to matrimonial, the matters relating to marriage, you will see that there will be a requirement for the Matrimonial Causes Act. So that is why those ones can also be sources of civil litigation. Alright, we have the Constitution of the Federal Republic of Nigeria. This is the ground norm. Most often than not, the Constitution is applicable in every instance. The Constitution is applicable in every instance because it is the ground norm. And by now, you should know that any particular law that is anywhere that has been established by anybody that is in contravention with the Constitution, that particular law will, to the extent of its inconsistency, be declared null and void. All right, the decisions of courts on procedure can actually also be sources, the one we call case laws. Case laws can actually be sources of civil litigation. These are not contained in any enactment or any rules of court. There is no case laws, are just decisions that have been made earlier by the courts. It can be referred to with respect to trials that are civil based. All right, practice directions. Practice directions have to do with the rules or the orders that have been made by the chief judge of that particular court or the chief justice of the federation as regards how a particular court is expected to be run. Such is known as practice direction. Practice direction are specific to specific courts, and it is often the chief judge of that particular state that makes practice direction. So such can also be a source too that can be referred to with respect to matters that relate to civil litigation. All right, on that, we're going to be drawing the curtain on the sources of civil litigation or sources of civil procedure in the courts, civil litigation. And until we meet again, do take good care of yourselves and have a pleasant night rest.